the moderator for this panel is Jimmy Kitchen. Jimmy is a partner in the Pittsburgh office of Jones Day, and he's also he's an uber former assistant U.S. attorney with vast experience, having served in the U.S. Attorney's offices in the Southern District of Texas, the District of New Jersey, and right here in the Western District of Pennsylvania, where I also had the honor of serving a number of years ago before I went on the federal bench. Jimmy has served as the Deputy Chief of the National Security and Cyber Section of the U.S. Attorney's Office and was designated as an Anti-Terrorism Advisory Council Coordinator and a National Security Cyber Specialist. We also have Alok Chakravarty, who is also a former federal prosecutor and who now chairs the law firm Snell and Wilmer's Investigations, Government Enforcement, and White Collar Protection Group, as well as the firm's cybersecurity, data protection, and privacy practice. As a federal prosecutor, Alok was responsible for investigating and prosecuting the Boston Marathon bombing case, among other notable cases. In addition, we are joined by Licia Niendo. Licia clerked on my former court, the United States Court of Appeals for the Third Circuit, for my very dear friend and brother, Judge Ted McKee. She is the Chief Legal Officer of Human Rights First, where, among other responsibilities, she oversees the advancement of high-impact litigation that addresses social issues, as well as the representation of refugees and asylum seekers. She is also a former federal prosecutor, and she has served, in addition to that, as the Commissioner for the New York State Division of Human Rights, as well as in a number of other capacities that directly impact equality and our overall social welfare and well-being. Excuse me. We are also joined by Arusha Gordon. Arusha is the Associate Director of the James Byrd Jr. Center to Stop Hate at the venerable Lawyers Committee for Civil Rights Under Law. And in that capacity, she focuses on hate crimes and incidents, and she supports communities and individuals who are targeted for hate, while also challenging white supremacy, which, as you know, the FBI has designated the single most dangerous domestic terror threat to this nation. Arusha has previously worked on the Lawyers Committee's Voting Rights Project and has taught public interest in civil rights law at both Howard University School of Law and the Washington College of Law at American University. And finally, we are joined by Beth Latrell. Beth is the senior supervising attorney for special litigation at the Southern Poverty Law Center. She has spent her entire career as a civil rights lawyer. Before she joined the Southern Poverty Law Center in 2018, she had been litigating cases on behalf of the ACLU, as well as Lambda Legal Education and Defense Fund, which is, as you know, the oldest and largest LGBT rights legal organization in the United States. We are honored to have each of these panel members with us today, and I now turn it over to you, Jimmy.
Thank you, Your Honor. All right. Well, welcome to our panel discussion here today. I'm really pleased to be up here on stage with these folks. I have, like all of us, have taken our share of lawyer jokes, but I got to tell you that one of the reasons why I got into this profession is because I do believe that lawyers are the modern day gladiators. We are the ones that actually resolve conflict, and in a way that it should be done in a civilized society. And we fight with our brains and pens and paper instead of with guns and knives. And I think that in this context, the difference couldn't be starker. When these folks here on stage are here to talk about how they use their brains to come up with creative strategies to fight against those that would fight in that non-civilized way. And so I'm happy to be here with the four of those gladiators, and I'm going to start with Leisha. Leisha, domestic violence extremism is a broad topic that has a lot of different moving parts. What are some of the areas of greatest concern in your view emerging from the domestic violence extremist movement?
Thank you, Jim. And thank you, everyone, for this opportunity to speak on this matter. At Human Rights First, we recently started a program unit dedicated to fighting extremism because we recognize how important this topic area is and how it ultimately threatens democracy itself. And we've always been involved in the human rights arena, but we specifically started an extremism unit to address this emerging concern. Extremism is guided, as you are well aware, by a belief that the presence and influence of certain other minority groups, namely Jews, immigrants, and Black and brown populations, will lead to the demise of America. This belief is known as the Great Replacement Theory, in that extremists believe that these populations are replacing them in society, and society must fight against these populations. While espousing white supremacist values, the extremism movement has also been undermining the rule of law and the public's trust in the democratic process, which is incredibly concerning. Nowhere is that more evident than in the 2020 election, where faith in both the legitimacy of the vote and the fair administration of elections was repeatedly attacked well before the election was even held, and then thereafter, of course. In light of the broad expanse of extremism, there are many areas of concern to which it has infused, but I would like to note, just for this audience, 5 of them in particular that are particularly concerning. First is the proliferation of malicious-style groups. We see these groups dressed like military or pseudo-military units, carrying shields, batons, and weapons, wearing army-type fatigues, weapons including guns, in fact, all intended to intimidate the public and generate a climate of fear. And this, of course, is on purpose on their behalf. Some recent examples of this are the June 2022 arrest of 31 white nationalists dressed in militia gear in Coeur d'Alene, Idaho, who were en route in the back of a U-Haul on their way to disrupt a pride event. In fact, the 911 caller who reported this to the police described these individuals as a little militia. Another example is the January 6th insurrection. That's a prime example, of course. A not insignificant portion of the January 6th insurrectionists were wearing military-style gear, brought weapons such as pepper spray and other eye irritants with them, and planned to breach the Capitol building in advance. Second area of concern, we are seeing a targeted effort by extremist groups to prop up and support election denier candidates for office. In the 2020 election, our democracy held in part because of a small handful of local and state election officials and governors, some of whom were in the GOP party, and they followed the rule of law and refused to be pressured into changing election results. Now, however, we are seeing election deniers running on the ballot for local offices this fall, which can have an absolutely huge impact and huge implications for the integrity of our elections going forward. In the upcoming election in November, half the country, or 55% of the population living in 27 states, has an election denier running among one of the top 3 state positions. The top 3 positions are, of course, governor, secretary of state, and attorney general. Specifically, election deniers are on the ballot for the November election in half of the races for governor, as well as 1/3 of the races for secretary of state and 1/3 of the races for attorney general. And there are 3 states with election deniers running for all 3 top statewide positions: governor, secretary of state, and attorney general. Those states are Alabama, Arizona, and Michigan. Third area of concern is recruitment of veterans, police, and former military into extremist groups. This is another huge area of concern. Of the approximate 900 people that have been criminally charged for the January 6th insurrection, around 100 have ties to the military. The insurrectionist who was shot and killed by a Capitol Police officer as she was trying to break into the House chamber was also a military veteran. These extremist groups are preying on veterans, purposely using patriotic language to entice them to their movement. They are cynically preying on their history of service to the country and their desire to belong to a cause, ostensibly so that they can save American values. Fourth area of concern is disinformation about our democratic process. Extremism has been infused into our news and other alternative news outlets. This disinformation presents itself as if it's a vetted fact, when in reality it's opinion or, at worst, even outright lies. Some recent lawsuits addressing this are the series of civil suits against Alex Jones and InfoWars that have been brought by the Sandy Hook families. For years, Alex Jones and his organization have been lying about what happened at Sandy Hook and monetizing off of these families' pain by spreading lies, claiming that the murders were a hoax and not real. The Sandy Hook families recently obtained a $4.1 million judgment against Alex Jones, and the cause of action was defamation. There are also ongoing separate suits against Fox News and OAN, brought by Dominion Voting Machines and Semantic Software, respectively, for defamation as well, involving lies that were stated by these outlets about these systems, Dominion and Semantic, changing people's votes during the 2020 election. And the fifth area of concern, and certainly not the last, but I'll stop right here, is the targeting of migrants using immigration invasion type language. The recent, quote, migrant invasion, end quote, language coming from border state officials is really just a variation of the Great Replacement theory. For instance, in Texas, the governor declared a migrant invasion in a July 2022 executive order, whereby he authorized the Texas National Guard to pick up any undocumented migrant found internally within Texas and drop them on the U.S. side of the border. And Texas and Florida have recently, and this has been in the news, been busing migrants to so-called sanctuary cities in the north, particularly Washington, D.C. and New York City, and dropping the migrants off in the middle of town with no notice to the governors of those states or the mayors. Texas has bused more than 7,500 migrants to Washington, D.C., and more than 1,500 to New York City. And just a few days ago, as you may have seen on the news, Florida put Venezuelan migrants on a chartered flight to Martha's Vineyard. Recently, I believe it was yesterday, the Texas sheriff in San Antonio has said he's opening up a human trafficking investigation based upon what he's aware of concerning the facts of that. So there's many areas of concern within extremism. I've just outlined a few of them. It's a non-exclusive list. This is a very broad topic, but there are civil litigation opportunities in all of these areas to potentially tackle the topic.
Thank you, Alicia. Well, so let's move then with that as the backdrop. Al, I know that when we were working together at DOJ, we sometimes had to get creative when we had to attack a potential domestic extremist issue versus an international extremist issue, at least as they're compared. Can you let folks know, the folks that may not be familiar with the law as it stands, the federal law, how does domestic extremism affect the tools available to law enforcement as compared to international terrorism?
Yeah, thanks, Jimmy. The law is designed to protect the civil rights of people in the United States, as well as protect their security, and that comes to a head when you're talking about domestic terrorism investigations. Both because the Supreme Court and because there has been a history of, frankly, abuse of sometimes internal domestic group investigations over the decades. The law has been constructed so that there is international terrorism. There are additional tools that you can use purely because of the international component, whether it be because the executive has the authority to designate certain groups, to put on blacklists, for example. Also, the ability to in addition to sanctioning these groups, to designate them as foreign terrorist organizations and then have certain associations with those groups also could give rise to criminal liability. Well, those don't exist in the U.S. domestic enforcement infrastructure. But that doesn't mean that there's not a lot to learn from our experiences combating international terrorism. One of the tools that we use frequently in international terrorism that we don't have as ready access to is the ability to get information, this surveillance, which unless you can develop an international nexus, it's much more challenging to get an Title III wiretap than it would be to get a foreign intelligence surveillance. And then some of the laws that you can charge somebody under for criminal offenses are in fact not available to a domestic terrorism. But there is a crime of domestic terrorism. I mean, that's defined. It just doesn't give independent liability. But there are a panoply of charges, as you know, sometimes simple charges, which, like providing false statements or obstructive conduct or firearms charges, which are equally available in the domestic context as well as in the international context. And that's why we have to sometimes get a little bit creative. So the proverbial spitting on the sidewalk, if it will accomplish your goal of preventing an act of hate or terrorism, or if it will get them into court and then with relevant conduct, you can seek a sentencing enhancement under the terrorism enhancement statute, then those are all possibilities. But it is more challenging sometimes, but that doesn't mean that we don't have the tools. And again, in balancing whether there's a big push to have a domestic terrorism criminal statutes, and recent bills have not had that element in there. And one of the reasons is because there is this history of sometimes of abusing the authorities that the executive may have to persecute domestic dissent. And you can imagine what would happen if all of a sudden certain groups were banned, especially right in advance of an election. You can imagine what that would do to our democracy, as Lecha was talking about.
Yep, absolutely. Beth, stepping away from government enforcement, what are some of the ways that the Southern Poverty Law Center is adapting or not its strategies to new threats that are posed by hate groups and extremists?
Let's see. I think in order to answer that question, I have to talk a little bit about what the SPLC does and how we do it. Mm-hmm. We are seeking to address racial and social injustice, and we have basically a three-pronged strategy. So one is educating, and by that I don't mean sort of just educating the public, but intentionally going into schools or providing resources to teachers, curriculum, lessons plans, that sort of thing, to ensure that the truth is told and racial justice principles are taught. And then, of course, we monitor and track and expose hate groups and extremists, and then we litigate. We file lawsuits seeking justice and seeking to dismantle discrimination. So the ways in which those three prongs have sort of had to adapt based on the way that hate manifests itself now. The education prong used to be called teaching tolerance. It's now learning for justice. And so that was from, I think it was 91 until 2020. We were teaching tolerance. We were trying to reduce prejudice. We recognize now that's not enough. Even with an expansive definition of tolerance, we are now learning for justice. And we've expanded beyond schools into centering our work in communities as well, which was kind of a good idea now that we see the way in which truth is being sort of pushed out of classrooms, and the truth about systemic racism, et cetera, is now sort of targeted. In terms of the litigation, the way to sort of think about how we're adapting, I think you've got to understand the kind of what I would call our legacy litigation. And that's the cases that SPLC brought in the 80s and 90s that literally bankrupted the Ku Klux Klan, right? So we sued in civil court on behalf of the family of a murdered man in Alabama who was brutally tortured and murdered to send a message to actually black juries. So there had been one interracial jury, and they did not convict the black man who was alleged to have committed the crime. And so they grabbed the first black person they found, black man they could find, and just brutally tortured him. We sued on the behalf of the family, and we sued the Klan, a Klan adjacent organization that owned the property, and then not only the individuals who were eventually convicted, but also others who knew about it and didn't do anything to intervene. We sued the Klan for burning a church to the ground. We sued the Aryan Nation on behalf of some motorists who, this is a kind of a random story, right? Their car backfired in front of Coeur d'Alene, is that how you pronounce it, in Idaho? The Aryan Nation's headquarters, and they were shot at, and they were driven off the road, and then they were kidnapped and tortured and beaten because they thought there was something nefarious going on in all of those. And then counter protests, because I think this is all sort of tied in. We sued the Klan for organizing what turned out to be a violent counter protest in Forsyth County, where some racial justice folks were trying to hold a peaceful protest. So in all of those cases, we sued under both civil rights laws that allow for sort of a private right of action if certain elements are met. We use tort law, which is just your basic, if you are harmed by someone, you can sue if you can meet the elements of those claims. And so we brought, in the case of the church that was burned, a trespass claim, just one single claim, and got the largest settlement or damage award to that point, I think, for a victim of a hate crime. And some of the other claims are just sort of ring in privacy. You mentioned defamation. I think the thing to sort of think about in terms of how we've adapted, all of these are still, there's very little adaptation we can make when the laws are the same. So we use conspiracy, where there's an agreement, agency principles, where the Klansmen or the white supremacist sort of members are acting as agents of, we're able to say they're acting as agents of the organization. In the case of the motorists in the Aryan Nation, we actually won a judgment based on, we brought a lot of claims, got to court, and the jury held them liable on negligence because the people who did the shooting were like allegedly security. So they were grossly negligent in the way that they trained them. So you can see sort of the way in which, none of it, civil rights laws aside, which I think you're going to talk about a little bit more, which directly fit the harm, but sometimes you have to be creative. So how are we adapting? We've brought a couple of cases under the same kind of theories of late. The case against Andrew Anglin on behalf of Tanya Gersh, where she was targeted by just an army of thousands and tens of thousands of white nationalists in her home and through every means possible. We sued under some tort theories and were ultimately successful in getting a $14 million judgment. And then another recent case was on behalf of a group of churches who were trying to help ICE settle immigrants and refugees and asylum seekers, and a group called the Patriot Movement of Arizona impeded that ability, trespassed onto their property, took pictures and video and posted online, claimed it was human trafficking, claimed it was sex trafficking, and we sued and brought other theories, including sort of interference with business relations, et cetera. So, you can only adapt so much. I think we'll talk a little bit more if there's time about challenges, but the victims in those other cases, or in heinous, egregious hate crimes, the harm is more physical, and now now it's in the cyber world, and it's a little more difficult to make those connections and to get those kinds of judgments. But I think that's our challenge, is to adapt to the ways in which hate is manifesting and harm is accruing, and are the consequences of that. And we've got to ensure that we can keep up. So we're adapting. I can't tell you all the secrets, but we've got some other things up our sleeve we're working on.
That's great. That's great. So Arusha, I'll turn to you now. What are some of the strategies that you've used to hold white supremacists accountable? And maybe you can tell us some of the results that you've gotten from those strategies.
Yeah, and this is wonderful to follow up after Beth, because we are constantly looking at SPLC's legacy cases and looking for the good precedent they set. So yeah, once again, Arusha Gordon with the Lawyers Committee for Civil Rights. For those who aren't familiar with the organization, we're a legacy civil rights organization that was founded at the request of President Kennedy to bring lawyers into the fight for equal rights. So we still have a very relevant mission. I'm not going to be out of a job because thanks to what's going on in our country. At the Lawyers Committee, I lead the James Byrd Jr. Center to Stop Hate, which is a newer team founded in 2017 after the spike in reported hate crimes and after the 2016 election. And our mission is really to use creative legal strategies and litigation. And I do say legal strategies because sometimes it doesn't arise to litigation, to fight white supremacy, to sue white supremacist groups, and also those who shield white supremacists. So, people who are dragging their feet in doing the right thing. And I will say, one of the things I love about my position now, I did voting rights law for 5 years before switching over. When I was a voting rights attorney, we used the same statutes over and over. Voting Rights Act, National Voter Registration Act, and the same claims underneath the Constitution. And it was kind of like wash, rinse, repeat. Great, important work. I feel like now, when you think about how do I take down a white supremacist group, it's like, I don't know how many people here are lawyers or went to law school. Okay.
Oh, nice.
Okay.
Nice.
So it's like your worst 1L exam, because it's just like issue spotting, and you're like, I could just do I use, and I find myself thinking a lot about my 1L classes, which honestly I never thought I would use again, but is there a contract law angle here? Property law? Is there torts we use a lot? I never thought I'd be doing tort law. And then, even more so, is there a public nuisance theory here? That's, something environmental groups have used very successfully, but can we use that to take down white supremacist groups? Is there an anti-racketeering angle here? Is there a copyright or trademark angle here? So there's all these areas of law that I get to nerd out on and, get to learn about, which I love about my job. And I think it's really necessary. So just to kind of give 3 examples, and I don't know if folks here caught our client yesterday. He was on a panel, Reverend Lamar, but in 2020, on January 4th, not January 6th, so 2 days before the Capitol was stormed, we sued the Proud Boys because the Proud Boys had rampaged through my city, DC, in the wake of Donald Trump losing, and had targeted different institutions, had assaulted a bunch of bystanders. And one of the churches they targeted was a historic Black church. They trespassed, they tore down property, they vandalized, all while celebrating and chanting white supremacist kind of slogans and cheering each other on. And so we sued. We used tort law again. So there I am brushing off my 1L textbook, casebooks. But we also got to, and I hate to be nerdy, but my favorite legal claim, who is a favorite legal claim? But my favorite legal claim in that case is a claim under the FACE Act, which is the freedom to access clinical entrances. So you might scratch your head and be like, that sounds like it has to do with, clinical entrances. And it does. Its focus is ensuring access to abortion clinics for women and healthcare. So you might be like, what does that have to do with this attack by the Proud Boys? Well, as part of a congressional compromise when that statute was passed, congressional Republicans pushed to have language in there that would also protect the right to access religious institutions. And there's a civil provision there. It has been very rarely used, but we dusted it off and we were able to apply it to our case. So that's why it's my favorite legal claim in that case. And we also use, as Beth kind of referenced, the Kkk Act, which it's fascinating to me because this was passed right after the Civil War. The name, Kkk Act, it was meant to target action by the Ku Klux Klan. And here we are seeing it used with renewed energy in 2020 and 2021 and 2022. It was used in the Charlottesville case that I'm sure folks heard about yesterday. I'm also on the legal team for a January 6th case where we're representing 7 Capitol Police officers. We have it in that. And it gets at this idea of a civil conspiracy to violate one's civil rights. So dusting off these really old statutes. And then again, kind of the third example I would give is not a case the Lawyers Committee has brought, but thinking about how can we use copyright and trademark law. So in 2019, I believe the creator of the Pepe the Frog cartoon character, which for folks who aren't familiar is like a green frog who's a cartoon. And it was appropriated by the alt-right. And so the cartoonist actually sued InfoWars, which had been using it, and got a settlement. It was $15,000, which I guess if you're Alex Jones maybe isn't that much. But again, it's just an example of like, how can we think outside the box to really hold these bad actors accountable?
Oh, great. Beth, I'm going to come back to you. You had alluded to some challenges, and it sounds like SPLC is plenty busy, but you seem to think that maybe there could be more cases. So what is the reason why, given the elevated threats, we're not seeing even more cases brought by SPLC?
So there's, there are a lot of them. So I'm just going to sort of tick off some of the ways in which today's hate groups are not yesterday's. So number one, they don't incorporate anymore. So we were able to get these large judgments against the groups themselves. So not just the whack-a-mole individuals who are doing bad things, but the entities who were inciting them, right, to and sort of fueling that hate that ended up with that result. So they're smart enough now after our cases that they don't generally incorporate. So there's no corporation, so it's harder to find them. They're no longer, or at least they attempt not to be as hierarchical, right? There's not the easy Grand Dragon, Grand Wizard, Grand Poobah, or whatever, this sort of hierarchy of clans where you could really tell who the leaders were. They are more and intentionally loosely organized. They are intentionally, in some cases, like Adam Waffen Division, which is a terrible hate group, or the base, sort of organized to be lone wolf actors, right? So it's sort of this intentional way in which they're organized. They're not directing people what to do. Both the organizations, and another problem that we have is that people organize on platforms now, right? They don't organize in barns or in those public spaces where they're easily identifiable, where there's sort of preaching going on from one place. It's just kind of they're organized in platforms. It's sort of a decentralized radicalization process that's going on. They use coded language where before they used to say, go get a black man and let's lynch him. And now they use coded language like race wars, like bringing down the system, and just sort of this other, codes of Night of the Rope or Day of the Rope. This coded language. They communicate in encrypted forums. I mean, like, stop me, when I've listed enough of the ways in which, we were able to actually when we got these large awards, they had assets. So we got their buildings, we donate them to the NAACP or whatever, but like they don't have sort of assets, which is not to say we can't come after you and come after the individuals and their personal assets. We can and we will. But there's an enormous amount of challenges, and I think the last one I'll end with is kind of there's two more, because I also want to say that a lot of the most heinous hate crimes end with law enforcement, and that's kind of a dead end for civil litigators to get the sort of digital trail that would show how they were radicalized, right? So everyone sort of stops at, like, we got the person, and every time that happens, I think, who is he connected to? But law enforcement comes in and does their job, and it's very difficult to get access to the digital trail. And the thing I was thinking as well, and I don't know if this is SPLC sanctioned, but it's just sort of the way in which white nationalists now wrap themselves in the American flag and in patriotism in a way that maybe it happened before. I don't know. I'll pretend to be young. I mean, I did not live through the civil rights movement, but it makes it, they're not in hoods, they're like in red hats, which is not to say everyone who wears a MAGA hat is a white nationalist, but all the white nationalists are wearing MAGA hats, and they're all, you sort of show up and interfere with people's rights. And I think that kind of just hidden, I guess, for lack of a better word, and in some ways, not hidden at all, ways in which the white supremacists and are showing up is just creates another level of challenge for those of us who are trying to hold them accountable.
Yeah. So you mentioned the digital trails. Al, I'm going to turn to you now. With the internet obviously being a factor here now and allowing amplification of extremist voices, how do we legally reconcile the freedom of expression with the dangers of radicalization?
Yeah, well, I mean, that's the $64,000 question, right? It's interesting, like what Beth talks about in terms of the decentralization. We dealt with this in the international terrorism context, and like Al-Qaeda morphing into ISIS, and then how were they going to connect with these homegrown extremists? And we wrestled with this very idea because frequently on the forums, and then there were fewer of them that were end-to-end encrypted, but we would have civil society get into those forums and share information with the government. But it's frequently this question of, well, is it just talk, or have they actually done something or taken a step on that continuum towards action? And clearly, if you're doing some kind of preparatory activity for violence, then that's going to be something that the government could intervene on. But more frequently, there is something else that might be doing, or it's encoded language, and you're not exactly sure how they are advancing the mission of either an organization or a loose group of people who are planning to do something that's hateful or terroristic. And in some cases, the speech itself can constitute a crime. It can constitute an action. For example, I see one of my friends, an former FBI agent out there. If she was asking somebody a question in the course of an investigation, and you lie to that FBI agent in a material way about what she's asking about, you can be prosecuted for that lie. You're not immune because of the First Amendment from liability for that. Similarly, if you engage in words as conduct, in the course of a conspiracy, for example. Perhaps, and there's no criminal defamation, but in the civil side, there's defamation. If you cross that line, then that's addressable. I know even before the Boston Marathon bombing, I had prosecuted a case about 10 years ago where New York Times, Washington Post were criticizing it for trying to push this line of prosecuting thoughts because somebody was creating propaganda for Al-Qaeda in the Arabian Peninsula and later for ISIS. There's constitutional case law. The Supreme Court has ruled, at least in that case, that at least in international terrorism, if you have designated terrorist groups and you're providing support for those groups by issuing propaganda to recruit people, just as Proud Boys and others are doing now, then that survives the strict scrutiny, constitutional scrutiny, to allow addressing of that speech. Now, that is not, as I explained in my previous comments, where we are in the domestic terrorism world. But there is a line, and it's a question of whether you're going to have aggressive prosecutors and civil litigants who are pushing that based on sound legal reasoning. And if they do, then I think, as in that case, there was the Mahana case, we were able to get a conviction and expose to some of the radicalization material, the digital material, to show how they got there based on this theory that you can't just be recruiting for these terrorist groups and expect to get away with it.
Yeah. So sticking with the topic of the internet and these kind of platforms where extremism is proliferating, Alicia, will you talk a little bit about how, as a practical matter, what are some of the challenges that in using the courts to hold social media companies accountable for hate that is posted on their forums, on their websites?
Sure. One of the biggest challenges is a federal law called the Communications Decency Act, which was passed about 25 years ago in 1996, when the internet was in its infancy and before companies like Google and Facebook and Twitter had even been created or were certainly not the force that they are today. The Communications Decency Act, it sounds like it's meant to protect you, and I suppose parts of it really do, but the flip side of it is parts of it really shield these platforms from any civil liability. It shields these platforms from civil liability for hosting hate speech and disinformation. It's a carve-out for legal liability for these platforms. It was passed so as to encourage growth of the internet and internet companies at a time when the internet was really in its nascence, and the US government really wanted to encourage growth of these companies, particularly growth here in the United States of these companies. But it really was passed before anyone could even envision the power and influence that social media companies and platforms would have on public opinion as a news source. And no one envisioned at the time that these platforms would be used as a means to harass and defame people and intimidate people on the basis of race, sex, and other characteristics. So Section 230, it shields these websites from liability for content created by their users, where it can be shown that the website is merely hosting the content rather than actively helping to create it. So a user can post hateful content or abusive content on a platform, and the target of the abuse generally cannot sue that platform for hosting the content on their site. Rather, the target has to figure out who the user is of the site, who posted that information on the site, and then sue that individual who posted the information. Section 230 also permits internet companies to moderate their sites, though, without being on the hook legally for everything that they host. It doesn't, when I'm talking about it, I don't mean to say that it gives a blanket legal protection. There's no protection for these platforms for hosting child pornography, for instance. That's written into the statute. They cannot host child pornography. They can't host violations of intellectual property, but they can host a lot of other really egregious things, things that are defamatory, that the target may feel threatened by, and also hate speech. Since it became law, the courts unfortunately have repeatedly sided with the internet companies, invoking a broad interpretation of immunity. For instance, as recently as 2019, the Second Circuit affirmed a lower court's ruling that Facebook was not liable for violent attacks in Israel, coordinated and encouraged by Facebook accounts linked to Hamas. So you may ask yourself, why can't this law just be amended? Well, it's a law from Congress. So as we all know, there's very little political will many times for Congress to act. And in this instance, tech companies argue and have a very strong lobby that any alteration of the Communications Decency Act could cripple online discussion and cripple the exchange of free speech. But the internet industry, as well, we are all aware, has a financial incentive to keep Section 230 intact. The law has helped build these companies to million-dollar, if not billion-dollar companies with a lucrative business model of placing ads next to largely free content for visitors. But as I've explained, you can see the problems with the law, and the problems are pretty obvious. We have to rely on these platforms to just do the right thing and be good corporate citizens and moderate content because it's the right thing to do, not that they could legally be on the hook for it. So with no guardrails, social media companies have been left to moderate as they choose, which means that it's a whole patchwork out there between what Facebook is doing, what Twitter is doing, what some of these other sites are doing in terms of what's acceptable content on their site and what's not acceptable. And also as recently as Friday last week, there's a slight twist. There was a recent Fifth Circuit opinion that came down on Friday where the Fifth Circuit upheld a Texas law that actually prohibits social media companies from taking down content based upon the viewpoint of the user. And Texas passed this law shortly after the January 6th insurrection, the Texas legislature passed a law shortly after the January 6th insurrection when we saw that Trump was taken down, he was deplatformed by Twitter. In response, the Texas legislature and the Florida legislature separately each passed laws requiring, or basically saying that these platforms cannot take down users based upon what they call viewpoint discrimination. This is now, it's working its way through the court system in the 11th Circuit in Florida and the 5th Circuit in Texas. Like I said, the 5th Circuit just upheld the Texas legislature's law saying that these platforms cannot do this type of moderation. The 11th Circuit has a completely different opinion, so now you have a split in the circuits. This will undoubtedly go up to the Supreme Court this term or probably at the latest next. But the real issue here in terms of holding these platforms accountable for hosting this hate speech and defamatory content is that there is no uniform national standard from Congress as to what they can do or can't, and to the extent that there is, the Communications Decency Act, these platforms are shielded largely from liability.
Great, thank you. Arusha, I'm going to turn to you next, and still talking about how we deal with these challenges and coming up with solutions. In your work using the legal system to hold white supremacists and other hate groups accountable, does that require a wide range of partnership and expertise? And who do you partner with in doing your work?
Yeah, so it's a great question because I do think, I know most of the folks here now are lawyers or went to law school, but we really can't do our work without partners, and I think that's part of what makes Eradicate Hate so important is making those connections. And I can speak for myself, I feel like as a lawyer, sometimes end up being just a little bit siloed. So yeah, I think first and foremost, we work with investigative journalists. I think almost every single case I have brought usually starts in a news story, whether it's just the Washington Post talking about how the Proud Boys rampaged through DC, or a Twitter user who posted. So I think, journalists. Data scientists, I know there's lots here, lots at SPLC, who are connecting the dots and helping us find the evidence we need and spend, I'm sure, too much time in places on the interweb that I would not want to spend time, but like looking for the evidence of collaboration so we can bring a civil conspiracy claim. Other partners, like we need private investigators. We're a civil litigation shop. So how do we identify these anonymous trolls who are operating in this decentralized landscape? We brought a case against Andrew Anglin, kind of a sister case to the Gersh case, and we were able to identify some of the online trolls there because we worked with pro bono partners who helped us out with a private investigator. And also security needs. I think one of the big challenges that, I don't want to be too depressing, here's the long list of challenges, but one of the big challenges I face is I can't tell you how many times I find a fact pattern. My partner's always like, just say what happened. You don't have to call it a fact pattern, but fact pattern, where I'm very excited. There's very strong claims. And then you talk to the impacted community members and they would make amazing plaintiffs and they're too scared. It's like, why would they do that? They're not going to see the money at the end of the day. There's nothing in it really for them except a thirst for justice. And it opens up their families to really terrible harassment. So I can't in good faith tell them it's going to be easy or quick. But it would be really helpful if we had partners who are, provide delete me accounts or online and in-person security services. So I think, it's really kind of a holistic approach that's needed to bring this type of litigation.
Great. So I do want to leave a couple minutes for questions, but in keeping with the theme of this seminar, we want to offer a deliverable as a group, and this group has thought about it, and it was actually a proposal set forth by Arusha to draft a memo or a white paper which identifies the 5 most pressing challenges to hold white supremacists or other hateful actors accountable and summarize potential solutions. So maybe you can expand on that idea.
Yeah, I think the idea really is to kind of encapsulate some of what has been discussed here. And distill it down, because I find myself feeling a little bit overwhelmed, there's so many challenges. But I think to really distill it down to, these are the top 5. name them, and then really think about potential solutions. So if the challenges are collecting judgments because it's all in crypto, or plaintiffs being scared and needing security in order to be able to come forward and file a claim, or defendants are anonymous, naming those and then kind of starting a conversation around what those solutions can be. And I think like this is just building off the work that we're doing at Eradicate Hate, but putting pen to paper to kind of capture some of that.
Great, great. So I am guilty of not bringing the iPad up here with me, and so I don't have any questions handy, but I thought we could do just kind of manually. Does anybody have any questions they'd like to ask this outstanding panel? Yes, sir.
Comment,
Okay.
and I'm not a lawyer, but I work.
You're still allowed to talk.
I work in Europe, in Strasbourg, which is where the European Court of Human Rights is located. And a few years ago, it passed a judgment in a case called Delphi versus Estonia, where Delphi, an online site in the Baltic states, had published defamatory material. And the court held, after considerable discussion, and it went from the lower court to the higher court, that Delphi had acted as a publisher by publishing this material, and therefore was held accountable for the defamatory remarks. That is now European law. So it's a very different situation to that which you described, and probably reflects the European attitude based on our history over the last 70 or 80 years. But I think it's just interesting to look at the two perspectives and compare them. Mm-hmm. And of course, there are other cases that have come before the court which have ruled that Holocaust denial is not a free speech issue, and therefore several Holocaust deniers have had judgments passed against them. Dieudonné, the French so-called comedian, who was indicted by the French courts on several occasions, subsequently took his appeal to the European Court, and it held against him.
I think that goes to what we were talking about earlier of this. In America, there is this First Amendment jurisprudence is so strong, and I think that's one of the reasons, even though the Communications Decency Act is an act of Congress, not of the Constitution, it's this principle that anything you're doing to chill speech is, countermands the human.
I realize and recognize that. We take a different view in Europe, which is harm, based on our experience. And therefore harm occupies a higher place in the rankings, perhaps, than free speech.
Yeah, and I would just add one more thing to what you said. What you said is very important. Just to extend that a little bit, I am aware a few years ago, it may have been 2016 or 2017, the EU passed a law called the Gdpr, which is a general data privacy law. The EU has really been much more on the forefront of protecting victims, if you will, of internet intrusions than the United States. And the GDPR holds platforms and social media companies accountable for not protecting the data privacy of users. And so it's a much more stringent law with real penalties, like tens of thousands of dollars, if not hundreds of thousands of dollars.
Of platforms.
Exactly. And it's applicable to all the platforms that are operating over there, including the Facebooks that are headquartered here, Apple, et cetera, Google. And so these internet companies, the platforms, they've had to adapt to the more stringent data privacy laws that are in Europe, even though in America, our privacy laws are less stringent. So Europe has really been more at the forefront of protecting users from abuses on the internet than what you see here in the US.
Yes, ma'am. Thank you.
Just to clarify that, under European Union law, so the e-commerce directive and the upcoming Digital Service Act, there is a liability exemption, and that liability exemption will remain. In the case quoted here, of course, and as you were also explaining, the liability exemption applies when you're a passive host in relation to the content, while not when you have an editorial involvement with the content. So from that point of view, the construct is very similar. Then, of course, under the European system, you can still, while not triggering liability for the criminal act, impose an administrative responsibility to take certain action in respect of illegal content that you become aware of, such as removing it.
Can I just say one thing about, I love the First Amendment, I want to keep it, and like the exceptions that are now recognized and that we count on, like imminent threat, like incitement to violence, defamation, like we need a new exception, and that means we need a new statute that recognizes the harm of disinformation and cyber, and hate online, completely unregulated, and we need an apolitical judiciary that believes in civil rights and plaintiffs' rights, and that's something that we can do by the votes that we cast.
All right. All right, well, we are out of time. I want to thank our panelists, and I want to thank the audience for their comments here today. I think that we can dismiss everybody at this point. Thank you.